two subjects, the first one being conflicts of interest and the second one being open and closed meetings. And I'll start out with an issue on the optional plan. The language that's got skipped over with regards to two conflicts of interest. Our code states that no member of the council shall have a personal investment in any business entity which will create a substantial conflict between his private interests and his public duties. Then it goes on to quote state code, indicating that a member shall abstain from any vote in which a member has a conflict of interest, a substantial interest. In state code 67-16-3, subsection 15 states that a substantial interest means the ownership, either legally or equitably, by an individual, the individual's spouse, or the individual's minor children, of at least 10% of the outstanding capital stock of the corporation, or a 10% interest in any other business entity. I've handed to each of you a copy of a conflict of interest memorandum that our office has put together. It kind of goes through the steps that one will take as they go through determining whether or not they have a substantial conflict of interest. Also, I've provided you with a financial disclosure statement. This one thanks to Dawn, who was able to help me manipulate the one that the state does with the state legislature. If you do have an interest in a company or a business or any type of organization that you believe that there's going to be a substantial interest, we ask you to fill that out and have it signed by the clerk. That is a requirement under state law to fill that out. Ultimately, and I know we're short for time.
Craig, one question.
Yes.
Is there a requirement to fill it out, period, or do we just do it if we have a conflict?
The state code indicates that an individual who has,
So it's if you have a conflict?
Yes.
That's what I thought. Okay.
it requires the disclosure of a sworn interest, if the interest is a business interest. Ultimately, I believe on the state level, we all fill it out anyway, based on the fact that most of them are involved in businesses that do deal with state issues. The biggest thing with conflicts of interest is it's always better to be safe than sorry. Ultimately, you've been elected to be here. You've been elected by the people to do your job and not to break the law and do things that are appropriate. So if you do have a question, feel free to bring it to Scott or myself, and we can go to that. We'll advise you because that's our job.
If we fill out this conflict of interest form just for being record, could we file it?
It'll be with the clerk, with Brent's office.
Is this scratched out 5? Is that a 2?
Yes, the state, their standard is 5,000.
Under number 4.
Yeah, under our code, it's 2,000.
Okay.
And so, in violation of this, if you are voting on issues where you do take an interest, it typically is a Class B misdemeanor. However, if you are advantaged more than $1,000, I think it get up to be a felony, and you can be removed from office. So hopefully we don't. Hopefully these types of issues are caught well before the legislation gets there. But if you do have any questions, please feel free to contact our office. The next issue that I was asked to talk about is closed meetings. You hear a lot of people discuss this as executive sessions. Under state code, it is open meetings and closed meetings, not executive sessions. And the requirements to hold a closed meeting is to get to a closed meeting, you have to have a vote by 3/4 of the members present. The reason and the location of the closed meeting need to be announced and entered into the minutes of the open meeting. I haven't seen an issue with that portion with the council because typically it's on the agenda and it's been announced. And there's certain specific issues that can be discussed in a closed meeting, and anything else should not be discussed. The The issues that can be discussed in a closed meeting are the issues above. To discuss the character, competence, or health of an employee or individual. As you said, Kendall, with regards to the competency or as you're appointing, going into a closed session to discuss these types of issues. As a legislative body, you can use a closed meeting for a strategy session dealing with bargaining, litigation, purchase, exchange, lease of property, or the sale of property. You can also go into a closed meeting to discuss the security of the county and those types of things that you can deal with. Investigations, certain complaints, and taxpayer information. If there's a closed meeting that should have been an open meeting, there are certain penalties that can come into effect. Any action taken in violation of this act can be voidable by court. A closed meeting violation is a Class B misdemeanor. If it's challenged and they succeed on that challenge, then the court will disclose the information that was discussed. So ultimately, the biggest thing is and as government moves more towards transparency is the key.
What's an example of number one? Any final action taken in violation of the act voidable by a court?
So if you went into a closed session,
take any action in a closed session.
exactly, but they have run into issues where
People have.
and that's the issue that comes up.
So we can strategize, agree, disagree, discuss, whatever, but any action needs to be taken back in open.
Yes. Unless it's something sensitive that deals with an employee and those types of things, certain action, well, not an ordinance.
Yeah, I mean, even with an employee, it might just be that the action would be whether or not you appoint an employee, that the discussion would be closed.
Yeah.
Okay.
You wouldn't decide in a closed session.
Okay. And so, I mean, ultimately, the goal is transparency with regards to those things and to be letting the public be involved and understand what's going on.
Okay, thank you. Any other questions from members of the council on their presentation? Thanks, Scott and Craig. Our next item on the agenda is the information on our